When an expert should be considered in a matter depends on the type of matter and who you're acting for, whether it be the plaintiff or the defendant. In my experience acting for plaintiffs, the first question for me to answer is whether an expert is needed at all. Does engaging an expert with specialised knowledge assist ultimately the judge in determining issues in dispute? If engaging an expert is not going to facilitate the resolution of the issues in dispute, then in that matter it may not be worth engaging an expert at all. There are some examples before the courts where his or her honour have not allowed costs for experts that were engaged that didn't facilitate the issues in dispute, or did not allow the full cost of engaging those experts because the court found in those cases that it didn't assist the resolution of those issues. After you've answered the question of whether an expert is needed at all, the next question will then be what expert should be engaged and when should that expert be engaged. It'll usually depend on the type of matter as to when an expert is engaged. In some cases, an expert will need to be engaged before court proceedings are commenced so that I can advise my client, or as young lawyers, we can advise our clients about the prospects of success or ultimately whether there are merits in proceeding with the proposed claim. Sometimes when engaging an expert early, as young lawyers, we need to think about what evidence that we have to give to the expert before the expert can provide us with their opinion. So usually in a matter, as lawyers, we would obtain as much evidence as we can, or as much documentary evidence as we can, prior to engaging the expert, so that the expert has at hand all of the relevant material that they need to consider, or that we want them to consider before engaging them. That way they have at hand all of the material that they need to consider and that we want them to consider in preparing their report.